Hi, it's Richard Cooper. I'm the founder and CEO of TotalDebtFreedom.ca. I've got Robbie Birnbaum on with me today. He is a partner at a law firm in Florida called Greenspoon Martyr. He's a lawyer. He is also the president of the American Fair Credit Council, which is formerly known as TASC. I wanted to talk a little bit about what went wrong in the U.S. over the last few years in the debt settlement space. Robbie, tell me what you know about that period of time and why you're qualified to talk about it.
Well, thanks, Richard, for inviting me on today. I'm happy to review it with you. My background, so you know, is that I'm an attorney at Greenspoon Martyr. As you said, I'm a partner here. I've been here for about 12 years now. Focused, and I run the department where we handle regulatory compliance, mainly we deal with companies that help consumers in various industries, including debt relief, and the government regulates them, whether it's the state AGs in the U.S., the FTC in the U.S., or in Canada, the provincial regulators. As for your question about what went wrong in the U.S., really what went wrong was there was in a big picture sense of things, there was a very low barrier to entry into the industry. And what we found is that when the mortgage meltdown occurred in the U.S., a lot of companies a lot of people who were in the mortgage industry tried to figure out what their next business would be, and they were looking for something to basically hold them over until the mortgage industry came back. So they saw debt settlement as an option, and they saw debt settlement as being an easy conversion for their existing sales staff and their marketing staff to get into, because essentially it's telephones, it's internet, it's direct mail, it's advertising to consumers. It's not that expensive to advertise, and they could reach out to consumers who they knew needed help because of their huge amounts of credit card debt. Well, while this was happening, there wasn't a lot of regulation to keep up and protect consumers specifically to the debt settlement industry. And what we saw, and what you and I lived through, was essentially a period where a lot of companies very quickly, probably over the past 4 or 5 years, or longer, 6 years, jumped into the debt settlement space, marketing very aggressively, and it became a numbers game. And the numbers game was basically how many consumers could you convince to sign up for your company or the company you were doing business with as quickly as possible. Specifically, they were problematically marketing statements and advertising and phrases that promised consumers things like, we will eliminate your debt quickly, or we have special government programs or special government connections, or we have power over your creditors, or we know your creditors and can work with your creditors. And some of the top complaints that we saw from consumers who were dissatisfied when they actually got into the programs consistently would relate back to what the marketers told them or promised them in the advertising. Things like, oh, you'll get quick results. We know your creditors, so we'll stop the harassment from the collection calls once you sign up. You won't get sued. Don't worry, because we've got special relationships in place with the creditors or with the government. These are special government programs was another one we heard a lot. And as most consumers know, a lot of them didn't because they were more vulnerable at the time, but they figured out later on that these companies couldn't really make those promises. They didn't, in fact, have special government relationships because neither the government in Canada nor the government in the U.S. even today has those relationships in place, and they didn't at the time.
Yeah.
And certainly the creditors who just want their money and want the bills paid, weren't giving out discounted programs in place, and still today they're not really in reality to most consumers giving any discounts out. So they realized that the so-called quick and easy solution, as usual, if it seems too good to be true, just wasn't there.
Right.
So we saw that, and those problems persisted until they reached the height, I would say, in around 2009, 2010, probably 2009 was the height, 2008, where we were seeing very aggressive television advertising, essentially pushing the government programs even more, with photographs of the President of the United States on there.
Yeah, I hear a lot of stuff about bailouts and that sort of stuff, right?
Right. Correct. We'd hear a lot of promises about government bailouts or special programs with the banks. And essentially the marketers were trying to link on to anything they could find that would give some impression of that their services were better than others, that they were government-backed, that they were important, that they would work quick and easy, and that if the consumer just paid them some money, they would take care of the rest.
Right.
Well, in reality, that's not true, and that didn't happen, and it's still not happening today. So, thankfully, the government stepped in and put some marketing restrictions in place, which helped clean up a lot of the industry in the U.S. And those restrictions focused on exactly what the problems were. Go ahead, sorry.
So, generally speaking, were these bad actors, and I know that there's some good actors down there because they're all a member of the AFCC, and I've spoken to a few of these owners at conferences that I've attended where you've been. Did they generally like overpromise results that they just couldn't deliver on in the back end?
Well, there's always going to be that division between bad actors and good actors.
Yeah.
The good actors even back then and still today weren't overpromising on results.
Right.
Their websites, their direct mail, all of it was very fair because they were really focused on customer retention.
Yeah.
And the way to get a long-term customer in your program and build that relationship, not just for the settlement service but for more services, is to basically keep the customer happy. And you do that through not overpromising. You do that through realistic expectations,
Exactly.
being the customer's partner in the program, holding their hand. The bad actors, however, which we still see a few in the U.S., and we see more in Canada these days, were basically, and are still promising consumers in Canada, they're promising that that those government programs are still around,
Right.
that there's some sort of relationship between their company and something the consumer wants, and only they can get the consumer to that promised land. But we
Right.
know that's not true. The settlement programs work in the good actors because they hold the customer's hand, they show them how to save their money,
Yeah.
and they the respect of not only the consumer but the creditor.
Okay.
Whereas the bad actors aren't looking for the long-term relationship, they're looking to get the consumer in the door and hand them off and make their upfront fee on the consumer.
Okay. Now, you've got state regulators at the state level, which are attorney generals in the U.S., and an FTC, which I believe is Federal Trade Commission?
Correct. We've got dual regulation in this country at the state level where the consumer lives, and then
Right.
at the federal level from the Federal Trade Commission.
Now, I understand they took some corrective steps to try to remedy the number of complaints that they got. Like, generally speaking, what did they do? I mean, I've heard stories in the media about fines being placed on some of these companies for several $100,000. Some of them were encouraged to refund money. Some of them were even shut down or shut out of certain states. Like, what was a general complaint or remedy that the state took when they got these complaints?
Sure. Well, briefly first, the general complaint that you'll ask any regulator, they will consistently tell you the top complaint from that period was that the company took the consumer's money and did nothing for them but promised great results quickly, and it didn't happen. Now, what did these regulators do? Well, in 2010, on a very constructive basis, what the Federal Trade Commission did at our federal level of government basically said across the U.S. that companies must make certain disclosures to consumers before the consumer enrolls in the program and before they even have the ability to charge the consumer any money.
Right.
Those disclosures include things about a good faith estimate about how much the program is going to cost the consumer and how long the program will run until they think they'll get settlement offers from the creditors. Disclosures that the consumer in a program may have certain downsides to a program, such as the effect on their credit score. And also, they put out a list of don'ts that a company can't do or can't promise a consumer,
Right.
which targeted a lot of the problem areas, like that's a government program, that's fast and easy, that they could stop the collection harassment or prevent the lawsuits, things like that. So a lot of very proactive consumer protection steps that whether you're in the United States, which is more regulated than Canada right now, or you're in Canada now, every company should be giving those disclosures.
Absolutely, and I totally agree. We've got about a minute and a half left. What lessons can Canadians as consumers and Canadian debt settlement companies take from what happened in the U.S. over the last number of years? I mean, there was kind of a rise and a fall of that sort of industry. Just talking about that for a quick minute.
Well, quite frankly, every consumer should keep in their head that if it sounds too good to be true, it likely is.
Right.
And when you break that down specifically for this industry, Canadian residents should really know who they're dealing with before they spend any money on that. One of the ways that they can do that is by consulting with their local consumer protection agency, by calling them or looking up the company on the website, or even more simply, when they hear the sales pitch or the explanation of the program for the company, they should be asking some very important questions. First, think to themselves and keep notes when they're talking to the company. What's the company promising? Are these the same problems that consumers ran into in the U.S. when they were overpromised? Is the consumer being told that the program is fast, easy, that there's special government relationships in place, or that the consumer is not going to be sued by their creditors for non-payment of their debt? Those are all hot-button issues in the U.S. that Canadian residents should learn from and look out for. Also, the consumer should look for a written cancellation policy, not just a verbal promise that says, oh yeah, if you're not happy, we'll give you your money back. Something on paper that's enforceable that says you can look at this program for, say, 10 days or 20 days before you make your commitment to buy. or at least you can get your money back if you're not happy once you go home and think about it.
Right.
There should be clear disclosures up front about everything the program offers, and there should be a dedicated customer service line to make sure that there's always someone there during business hours to answer a question from the consumer.
That's great. Well, thanks for taking some time to talk to me today, Robbie. That's been great. I think that's a very helpful bit of information you've dropped on us there. Thank you.
Thanks, Richard. I appreciate it.